I think you're playing games with the legal system. I think you are attempting to try to divert or to avoid this court's rulings previously. I don't think you have any basis to include that real property in the bankruptcy action that you filed. You are getting some bad advice, and I'm telling you right now that that bad advice from whoever it's coming from, whether it's your girlfriend or some other person, whoever's giving you advice on how you can subvert and get around this court's rulings regarding this case is giving you bad advice. It's going to likely end up in you being incarcerated in jail. I don't want to put you in jail. I want you to comply with the court's orders.
Your Honor has already ruled that that real property is Miss Patton's.
Agreed.
And he is holding a necessary insurance check that Your Honor has already said was awarded to her. This divorce has been completed for some time. Real property was awarded sometime. He's tried to backdoor it by filing a lien in the Register of Deeds office. This real property is fraudulently being placed into the bankruptcy court, and it should not be.
That's for the bankruptcy court. I agree with you. I agree with everything you've said. He has no basis to include this real property in the bankruptcy action. But a bankruptcy court is the sole judge, the sole area that allows for the for the determination of whether the asset that is alleged to do that. So Mr. Patton is treading in very thin ice with the bankruptcy court because likely the bankruptcy court is going to find, as I have ruled, that he doesn't own an interest in that property. And as a result of that, he has attempted to defraud the bankruptcy court, in my opinion. And I think that the bankruptcy court will need to have an opportunity to determine that because there's an automatic stay on any proceeding involving property that's alleged to have been included in a bankruptcy action until that bankruptcy court does that. But it doesn't stay this court from finding Mr. Patton in contempt of this court for failing to abide by this court's orders. You have not filed a motion for contempt, but I expect that's what you will do next.
That is what I will do next. We found out this notice was shoved into the door at my office in the middle of the night last night. So we've just found out about it this morning.
The notice of what?
The notice of bankruptcy. So that being said, I did want the court to know about the lien. He is still holding that check hostage. And he has filed some motion to have me disqualified as counsel because his girlfriend has some sort of relationship with Hidden Valley Properties, which our office represents, which is...
Let's hear that motion first.
Okay.
I'll allow him to argue that motion. You filed a motion to disqualify Reynolds, Potter, and Reagan in Vandervoort. You drafted this personally, did you, Mr. Potter?
Yes, I did, Your Honor.
Okay.
So at this time, Your Honor, I am preserving my motion to disqualify under Tennessee Supreme Court Rule 8, RPC 1.7, 1.9, 1.10, based on overlapping representation and confidential information concerns.
All right, I'm here. Anything you want to say?
I mean, I would like to preserve that for a future.
Reserve what?
The motion to just...
Now, we're going to go forward with the motion for disqualification today. So you can argue it, and I'll rule on it. Tell me why you think that this relationship that you set forth with Mr. Vandervoort, being the attorney of record for a realist from some sort of Hidden Valley Lakes or whatever.
Okay. Your Honor, regarding my motion to disqualify, there's a severe conflict of interest that breaches attorney-client confidentiality. Ms. Duke's firm represents Hidden Valley Lakes and its president. I volunteered there, and highly sensitive and private details regarding my active divorce were directly shared by this firm, or with this firm, by the president and Mr. Vandervoort. Opposing counsel has access to confidential information that can be obtained through that representation, and that creates prejudice against me with regard to the divorce matters that completely undermine the integrity of these proceedings.
All right, I've considered your motion to disqualify, and I've reviewed your basis for that, and I find that there is no basis for disqualification of Reynolds, Potter, and Reagan that the basis that you have set forth would have no effect upon this proceeding, nor would it have anything to do with Mr. Duke's representation of Mrs. Patton. Was there any other motion that needs to be dealt with today? Ms. Duke, I want you to draft an order that this court finds, as I have previously found, that this court has previously ordered Mr. Patton to execute the deed to this property as was ordered originally in the divorce decree, that he has been... The notice of lingua pendis. So that would be a situation where this court would have to deal with that, but I think the bankruptcy court's going to have to deal with that. But I will stand by the order that the court has made regarding the check that was from the insurance company, because I believe that was part of my earlier ruling, that he has 5 days to execute that check. And if he fails to do so, I will hold him in contempt. I think you're playing games with the legal system. I think you are attempting to try to divert or to avoid this court's rulings previously. I don't think you have any basis to include that real property in the bankruptcy action that you filed. You are getting some bad advice, and I'm telling you right now that that bad advice from whoever it's coming from, whether it's your girlfriend or some other person, whoever's giving you advice on how you can subvert and get around this court's rulings regarding this case, is giving you bad advice that's going to likely end up in you being incarcerated in jail. I don't want to put you in jail. I want you to comply with the court's orders. But I'm not going to tolerate you playing games. And I don't think the bankruptcy court's going to do that either. And so you might get prepared, because I think the bankruptcy court, when Ms. Patton hires a lawyer and they proceed in the bankruptcy court, they're going to take a dim view of you attempting to use that process. Anyway, that's the order of the court. You may step aside. You may.
So, Your Honor, I had 2 other things that I'd like to discuss if possibly.
What are those?
So I would like to be on the record. I'd like to preserve that the deed was recorded before the written order was entered under Tennessee Rule of Procedure 58. A judgment is effective only when written and entered. And third, the deed acknowledgement is defective because I was never personally before a notary. And then, like I said, I asked that the property issues be continued. As far as the check, I have no knowledge of where that check is or where it's supposed to be. Ms. Duke told the court that it was at her office, and I agreed to go sign that check at the office. She later told me that it had been mailed to somebody or somewhere. And at that point in time, I have no knowledge or receipt of this check, Your Honor. So it's not a matter of trying to get around not signing it or avoiding it or anything like that. I have no knowledge of where this check is, and I've not been requested by Ms. Duke to come to her office and sign for this check.
Judge, we have confirmation and tracking that it was dropped off at Mr. Patton's home. And I can't control where the insurance company sends a check. I represented to the court that as they had told us, they were going to send it to my office. They did not. We've got tracking to show that it was sent to his house. He knows he has it, and he's refusing to provide.
Once again, Your Honor, I do not have the check. Never received it. If it was mailed to the house, it's not at the house. So,
Ms. Duke, this court will order the insurance company to issue that check in your client's name only and to issue it directly to your office. And by order of this court, I'm directing the insurance company to issue the check solely to Mrs. Patton, and because she is the true owner of the property, and it's to be issued and mailed to your office, sua sponte. Secondly, your request regarding, or your objection regarding the deed execution is overruled and denied.
Understood, Your Honor.
And I will point out, the original order trumps everything.
This court ordered it from the bench. And it's just like any other order in this court. If it's not in, even though it may not have been a written order at that point, you were ordered to do certain things and you did them. So it doesn't matter if you signed the deed because I ordered you to do so. And later saying, well, that order hadn't been, the written order hadn't been entered, is an attempt to, again, subvert and get around what this court says. Why would you object to the order being, why do you even object? Tell me why that is.
Because I've filed a motion 60.02 to contest this whole process, Your Honor. So it's been under contest since I filed my motion 60.02. And then Your Honor ordered me to sign a quitclaim deed over on the 10th, or excuse me,
Well, I'm
the 15th.
overruling your objection to the deed because of the fact that this court is of the opinion that you did so in compliance with the court's order. Your Rule 60 motion will have to be heard after the bankruptcy court deals with you.
Well, and it was in compliance with the final decree, so it even goes back that far.
There is nothing in the decree that states that I am to sign a quitclaim deed, Your Honor, and give up my rights to a $150,000 debt. It's attached to a $150,000 debt.
All right, I've made my rulings.
Understood.
Thank you, Judge. I'll submit an order.
CV 77, Claiborne versus
Good morning, Your Honor.
Walk. He's in a wheelchair. We're in a hospital bed. We feed him through a tube in his stomach.
Oh, ma'am, does Randall, can you tell me what conditions Randall suffers from? Or is Thomas, I'm sorry, Thomas.
He suffers from seizures. They're uncontrolled. He takes medication, and we've tried different things like a vagal nerve stimulator, which didn't do anything. And we have done all sorts of medicines that really haven't done a whole lot for him. And he's had the front 50% of his brain divided in half to see if that would stop them. And only thing I can say about that is he could have up to 12 grand miles a day. And he stopped having that many in his, but he still has a lot per month. He's on a drug right now. They're trying him on to see if it. And of course, he's 53, and he's been having them since he was little.
Do they, either of your sons have the ability to make decisions or live independently? And they both reside in a special needs home, correct?
That's correct.
Who are their treating physicians, do you know?
Yes, Susan Osborne.
And that doctor completed a physician report, correct?
Yes.
And we would file that report with the court, correct?
Okay. I don't have a name. But she's the one that handles it. He signs off on her.
Okay. Do either Randall or Thomas have any significant personal property? And they both receive Social Security benefits, correct?
That's correct.
And you are able to ensure their money is managed correctly?
Development Services does manage the money, but
And you coordinate for their needs through the special needs home, correct?
yes,
And you ensure all of that their needs are provided for, correct?
yes,
And is it your desire to be appointed a co-conservator for your sons Randall Bowers and Thomas Bowers?
yes, sir.
Is it your desire to have have Francis Robertson and Horace Carlton, Randall and Thomas's aunt and uncle, appointed as co-conservators with you? Do you believe that this conservatorship is in Randall's best interest?
Yes, I do.
Do you believe this conservatorship is in Thomas's best interest?
Yes, I do.
Do you desire for a property management plan to be waived from your requirements from the court? Property management plan.
What that means is, ma'am, the law says that if you have assets of a person that you're going to become their conservator, and let's say they have a bunch of money in the bank or they have real property, then you would have to file what's called a property management plan that would allow me to see that you have a plan to properly manage their assets. I'm understanding that both your boys only have Social Security benefits and they're in a assisted living or a supervised living, and that money, I assume, goes to pay for that?
Yes,
All right. So I'm going to waive any sort of requirements for a property management plan.
Do you desire for a bond to be waived? Have to do that.
You don't have to ask her that. I'm going to waive the bond for you.
Thank you. And, Your Honor, I have Ms. Frances Robertson.
Yes.
Can you please state your name for the record, please?
Frances Robertson.
And have you heard everything that Ms. Bowers testified to as true and correct to the best of your information and belief?
Yes.
What is your relationship to Randall and Thomas?
I'm their aunt.
And do you desire to be appointed as co-conservator?
Yes.
And do you believe this appointment would be in Thomas and Randall's best interest?
Yes.
Mr. Horace Carlton? Please.
Horace Carlton.
And have you heard everything Ms. Bowers testified true and correct to the best of your information and belief? And what is your relationship to Randall and Thomas? Do you desire to be appointed as co-conservator? And do you believe this appointment is in Thomas and Randall's best interest? Absolutely. Your Honor, I'd like to pass up two
Right.
orders, if I could, please.
I have signed both of your orders and granted your request for conservatorship.
Thank you, Your Honor.
Good luck to you.
Thank you.
Twenty 26 CB 216 in re of Corey Michael Gilman.
Good morning.
Morning.
Would you raise your right hand and let's place you under oath?
Do solemnly swear or affirm.
Yes.
Good morning. Are you Corey Michael Skillman Vidlich? How do you pronounce the last part?
Vidalich.
Vidlich, all right. You have filed a petition for a name change, and I'm required by law to ask you certain questions. Are you asking to change your name to avoid criminal prosecution?
Sir.
You're asking to change your name to avoid your just debts or creditors?
Sir.
You're asking to change your name for any illegal or inappropriate purpose?
No, sir.
Then I think it's just, you want to just change and drop the Skillman part and go by Corey Michael Vidlich, is that correct?
Yes, sir.
And that's to match your Social Security Administration. All right. Then have you prepared an order that grants that name change?
Yes, sir.
We have the petition, and there should be an order that
Yes, sir.
you have prepared as well. I'm going to draw a line here on the last page of your order that for you to sign off on, just because of the fact that I need you to hand that to him, if you will, please. That way you can, we'll have proof that you were here that day and you were approving the order. All right, I have signed your order and granted your name change request. You can get a copy of this a little later in the day from the clerk's office, okay?
Thank you.
2026 CB 228 in re of Chance
Yaros. Come up, please. You will raise your right hand. Let's place you under oath.
Do solemnly swear or affirm.
You have, are you Chance Curry, is it Yaros?
Jaros.
Jaros, okay. Mr. Jaros, you have filed a petition for a name change, and I'm required, as you heard me, to ask you some questions. Are you asking to change your name to avoid criminal prosecution?
Yes, sir.
Are you asking to change your name to avoid your just answer creditors?
Yes, sir.
Are you asking to change your name for any illegal or inappropriate purpose?
Yes, sir.
It's my understanding that you want to just change your name to simply Chance Curry, is that correct?
Chance Jaros Curry.
Okay.
There should be an amended petition.
All right, an amended petition, I'm looking at the original ones.
I have a copy if needed.
No, I haven't. So what you're wanting to do is to change your name from Chance Curry Jaros to Chance Jaros Curry?
Yes, sir.
Okay. Have you prepared an order?
Yes, sir.
You'll submit that to the bailiff. And again, I'm going to ask you to sign on the line I've drawn there just to show that you have approved the order. I've signed your order changing your name. You can get a copy of it a little later in the day from the clerk's office once they get the file back over there. Okay.
Thank you.
26, CB 112, Christopher Powell versus Ashley Mallett.
Left in school and left. We filed this petition. It was filed on April 14th. We had her served out of state on April 23rd. I set a matter for a hearing on May 18th before Judge Lockhart Mash. I believe the evening before the hearing, I received an email from Ms. Carpenter stating that she had been retained. I appeared before the court because, again, the children have left. My client went to visit with them and got the police called on him there. So when Mrs. Mal appeared before the court on the 18th of May, she was placed under oath and had to affirm on the record that she had in fact retained Ms. Carpenter and paid her in this matter. And based on that, the judge continued the hearing. And we had a hearing on May 29th where Ms. Carpenter and I just reached an agreement where they were just going to do equal time during the summer. And it was set tomorrow. It is set for tomorrow because the children, again, as your Honor's aware, Dixon County schools start on Monday. And so it is a matter that needs to go forward, and it's set tomorrow in front of Judge Lockhart Mash, and she's heard the other matters involved in that, so.
Well, wouldn't it be more appropriate for Judge Lockhart Mash to hear the motion to withdraw?
Well, yeah.
It's going to affect her hearing tomorrow.
Well, again, and that, my position is if Ms. Carpenter if there's been some violation of the attorney contract by Ms. Mal, I certainly don't think she should have to be an indentured servant and represent a client who hasn't paid her, or is not cooperating, whichever it is. I know ethically she doesn't have to disclose that, but she said there's been a breach of the contract. So as a result, if she wants to withdraw, certainly she has every right to do at that. But the hearing is set for tomorrow, and I implore the court not to give Ms. Mal any additional time to file
Well, it's not
count.
my hearing. It's in front of Judge Lockhart Mash.
And I have filed a motion for default set for tomorrow also.
Ms. Carpenter, I'm willing certainly to grant your motion to withdraw because obviously, as Ms. Roberts said, if there has been a breach of your attorney-client relationship, then, you have the right to withdraw. But I am not in a position where I can continue a hearing in front of another judge anyway. So your client will need to be here tomorrow morning with the minor children for that hearing in front of Judge Lockhart Nash.
Your Honor, I'm striking the motion to withdraw. I just wanted to find out if the court wanted my client there in person. My understanding is the children are in Tennessee with father for parenting time currently. So I'm just asking if the court wants us in person tomorrow, which is fine.
Judge Lockhart Mash does not allow appearance via Zoom.
All right, she needs to be here because Judge Lockhart Nash does not allow the Zoom appearance. So if you're striking your motion to withdraw, then
Judge, this is our motion to dismiss for failure to prosecute. I think the case.
how are you doing?
Not real good today.
Well, it doesn't look like you're doing
I think
it.
it's going to be Monday before I'm back at it, but
Anyone who's had surgery yesterday and shows up for court today has got to have a leather strap somewhere to chew on is all I can say. So.
I had one matter I didn't feel like could be reset.
All right, this is a motion to dismiss for failure to prosecute.
Yes.
You represent the respondent mother, Desiree Fluellen.
I do, and over the history of the case, Your Honor will note that Ms. Roberts was involved for some time, and I would hazard to guess, just like she hazarded to guess a few minutes ago, Mr. Phelan did not cooperate in communications with her. We've sent this motion to him by email. We've sent this motion to him by mail, I believe, and we're just asking that it be dismissed for failure to prosecute.
Matthew Phelan. All right, case is dismissed for failure to prosecute.
Thanks, Judge.
Your Honor, while Ms. Duke is up there, tomorrow, I have filed a motion asking to continue. I request the court there.
I think that would be appropriate. This is you and Ms. Duke.
Yes, and Ms. Duke and I are involved in it.
And I didn't know if we could get a reset date on that while we're standing here.
Fine, I can try to give you one. What case is it, the Jones case?
Jones versus
Jones.
It's a Humphreys County case I agreed to hear here, right?
Yes.
And I just handed up to you an agreed order. Ms. Duke and I were able to resolve the real property issue, and we've signed an agreed order. I may have dropped that out. That's not, I think that's one of them up there. I was going to get you to sign, and I'm going to take it back to the Humphreys County.
And this is one that we did a really short reset on this one, just so that Mickey could get in touch
Let me hand this
with.
back, please, to Ms. Roberts.
The guardian ad litem wasn't available, and we need to move it, so we don't have her here, so.
If we could get 2 dates and then us just talk to her about it, I think we should be able to
She's
work it out.
downstairs in juvenile court. Today's her juvenile court day.
I could probably give you how long do you think it's going to take?
It'll basically just be a custodial determination. Testing agreement. Back to the home on Thursday.
I gave the children the home and gave your
Children
parents
the home.
visitation
We
with the
resolved
home.
that, and she's buying the home, we're gonna refinance it. My client's moved out, so it's an establishment of a residential schedule.
And Your Honor has heard quite a bit on this already. I think we probably won't go back behind the last order. I don't intend to. Ms. Roberts, I don't expect would, but so maybe over the last year, you'll hear testimony about that stuff.
But thankfully, all the kids are of age that they can testify.
I will repeat my question. How long do you think it's reasonably,
3 hours.
realistically?
3 hours, I think, is a fair.
All right, well, the reason I'm asking is, I don't have any open dates for the entire month of August, but I don't really have any open dates in the entire month of September. Now, I have August the 18th, which I am scheduled for Houston County Chancery Court. And I talked to my clerk yesterday, and originally I had told her to take that day off because it needed to be, I was trying to give something to Chancery, but I could probably give you the afternoon of the 18th.
I had 2 days in August that I'm available, the 18th and the 21st. Other than that, I have no other dates.
Right.
I'm in court every day other
No.
than that, so now I only have 1 day off.
Where will we hear that?
Where you want to go? You want to go to my hometown of Erin to hear it?
That's fine.
You
with
want me to come back here, I can do it at 1:30.
I think here would be
I
great.
think given the construction in
Oh, that's
your
right, yeah.
house, that may be.
They're adding on to the courthouse there.
And you have to kind of get to the elevator, again, the EDA scenario, you go down the steps to get to the elevator. And then get, so I would rather,
All right.
do it somewhere where,
Well, I will let Ms. Brooks know that she has the morning, but that you have the afternoon, so.
What day of the week is that?
that's on a Tuesday.
Hopefully Mickey will be fine on
You want to
If-
double check with Mickey before
If
we,
she's not, then we'll circle back around. I have court with her this afternoon at 1 o'clock. She is, and so in juvenile, so I will check with her, and if that's not available, we'll get back to her.
now who has the Jones file?
I talked to Miss Abby. I told them that I wasn't going to bring it because I anticipated she might be able to grant a motion to continue. So I will text Miss Abby and tell her I'm not coming to get it.
All right. Do we have anything else set tomorrow morning? There's nothing other than Jones, right? Okay.
Ms. Roberts and I have a few matters, but we're working through those, getting those reset.
But those are from Judge Dr. Mash.
Yes.
All right. Is that all you had, Ms. Duke? Call the next case.
2025 CV 255, Bruce Green versus Connie Lumpkin.
This is here on my motion to either compel Ms. Lumpkin to sign, to appear at the closing, or in the alternative, ask the court to allow me to enter an order divesting her of ownership of the property, investing it with Mr. Green for the sole purpose of concluding the closing on the sale of the properties. This is a case, Your Honor, wherein I filed a partition suit. Previously involved, they purchased 2 vacant lots together. There has been significant amount of litigation in General Sessions Court, and then in Circuit Court on this matter. So we had to file a partition suit here. Your Honor granted the partition via default. We appeared before the court, got an order to sell the property by auction. Mr. Neil Trice effectuated the auction. It was sold, and we came before the court on March 23rd of 2026, and you approved the sale. The closing has been set. Ms. Lumpkin has failed to appear, has failed to file anything, has been served with this, is not present in the courtroom, has never appeared. And so I would request, Your Honor, I'll put on Mr. Green to verify what I have advised the court, and we would just ask for an order divesting the property with him for the sole purpose of him executing and closing the 2 contracts for sale on the property, and that all proceeds be deposited into the court after the cost of the sale, which you've already approved in the court order, and then have Ms. Lumpkin come before the court. The alternative process is for me to file a contempt petition, her to be jailed until she signs it. I do not want to do that. I think this is the most expeditious way to get this matter closed and the money paid into court.
All right, Mr. Green, raise your right hand. Let's place you under oath.
Do solemnly swear or affirm that the truth,
You are Mr. Bruce Green, is that correct? Yes, ma'am. Mr. Green, during the time that you and Mrs. Lumpkin had a relationship, y'all purchased 2 lots out on Furnace Hollow Road, is that correct? Yes. There has been a significant amount of litigation downstairs in General Sessions Court. It got appealed, it was in Circuit Court. Mr. Potter represented her. We went through a number of things. We were able to resolve that, but y'all still ended up owing those 2 pieces of property together. Attempted to negotiate with her to get that taken care of, all failed, correct? We filed a partition suit, served her, and she failed to appear or file an answer, is that correct? And we took a default judgment and then came before the court to get permission to sell the property by auction. We retained Neil Trice to do that, and he effectuated that and sold both pieces of property by auction, is that correct? That's correct. We came before the court, presented the sales price, and this court approved the auction. The closing was set, you appeared to get everything and signed everything. You have a contract pursuant to this court order, 2 contracts that need to be closed out. Is that correct? That's right. And you understand what I'm asking the court, what we're asking the court is for you to be vested with the property for the sole purpose of you signing the deeds to the new purchasers. Then the funds will be deposited with the clerk and master, and we'll have to come back another day to decide how it's going to be divided. And you're asking the court to do that. And again, we discussed the option of filing contempt and doing that. And again, this is the most expeditious way to fulfill your obligation under the contract that you signed.
All right, I will grant your request to authorize Mr. Green to solely be able to execute the deeds necessary to close on the sale of this property.
Thank you, Your Honor. I'll get the order over to you.
2019 CD 230, Michelle Santiago versus Fernando Santiago.
That is a show cause order. I've actually, it's amazing how a show cause order can get someone's attention.
Turn that microphone just, there you go.
It's amazing how a show cause order can get someone's attention, a motion for show cause, that is. I have been in touch with them, and they are working on it. The lady is out of town this week, so if we could just pass that to another date. I don't know what dates it really does not matter what date.
Doesn't matter what judge, we can give you the next, how long away do you want it?
Instead of
So August the 26th.
the 26th will work just fine.
T25 CV 289, Michael Thomas versus Rachel Thomas.
Your Honor.
Good morning.
Morning, Judge.
We are here today. We got a couple different motions that are on this. We came here previously and the court said at that time that should an interlocutory appeal be sought, that the court would approve that. We now are asking for that interlocutory appeal formally, which I think under the rules I have to do at that point. And additionally, we are seeking the statement that the Court of Appeals requires of the trial court in terms of what is being appealed and why the court believes that it's necessary.
What if the judge who's granting the interlocutory appeal thinks he made a well-reasoned and informed decision that the Court of Appeals would certainly uphold, but you are saying I need to draw an order that, or a statement for the appeal according to the rules? That is what is said.
Correct.
This is a case, clearly, and do you want to respond to any of that? So.
Judge, I would like to respond on the motion for stay, certainly. I don't think a stay is appropriate in this case. This court's already held that it's got jurisdiction. That order is in effect currently, and that order is going to be in effect until and if the Court of Appeals overturns that order, and that's an if that happens. So I don't think a stay is appropriate in this matter. If the court is inclined to grant a stay, I think that stay should only be applicable to baby Thomas that is in Colorado. We have 2 minor children here. Scarlett Thomas is still with mother in West Virginia. The appeal is solely related to the court's exercise of jurisdiction over baby Thomas. So if the court's inclined to grant a stay, I think that stay should only be applicable to baby Thomas.
And I didn't touch on the stay. I was going to take those as 2 separate aspects of it because I think those are 2 separate aspects at this point.
All right. It is this court's opinion that in what I stated before, this is one of the more unusual cases that I've had come before me. This is a case where, based on alleged domestic violence, which I'm understanding from Mr. Kirby, that Mr. Thomas has either pled guilty to or been found guilty of some sort of domestic violence in the past, and that led Mrs. Thomas to relocate to the state of West Virginia with the party's 1 minor child, but she was pregnant at that time, if I recall correctly, and gave birth to that child and then placed that child for adoption with a couple in Colorado, and that there is a Colorado court exercising jurisdiction over that child, or at least attempting to exercise jurisdiction over that child. Mr. Kirby's argument is that that child, that this court does not have jurisdiction over that child. I am of the opinion that this court, once I assume jurisdiction over the divorce between the parties and any minor children that the parties had, that this court has jurisdiction over any child that is born during the pendency of that divorce action. And for that reason, I am of the opinion that this court is the appropriate venue for all matters concerning the minor children. The Mrs. Thomas, through Mr. Kirby, is asking for an interlocutory appeal on the issue of whether or not this court, solely on the issue of whether this court has jurisdiction over the minor child born to Mrs. Thomas and Mr. Thomas, because the DNA test results have shown he is the biological father. And if you are asking for an interlocutory appeal, you understand, if I grant the interlocutory appeal and state the reasons why, it still is up to the Court of Civil Appeal to determine whether they'll even grant that.
Correct.
So a stay as to that child would simply stay this court's exercise of jurisdiction over that child. My concern is whether or not that means that the Colorado court will continue to proceed with the adoption proceedings in the state of Colorado, because if what I don't want to do is grant your request for an interlocutory appeal and then issue a stay order on this court's exercise of jurisdiction over the newborn child that allows the Colorado court to say, hey, we've got jurisdiction because the Tennessee court has stayed that in its own appeal, and that gives them somehow a leg up. That's, I think, would be unfair to Mr. Thomas in that regard. So how do you address that? What is the status of the Colorado proceeding?
The last time, and I've been in communications with the attorney for the petitioners in Colorado at this point for the adoption, they are still going through the jurisdictional argument aspect of things in Colorado as well. The petitioners had submitted their brief on that. I believe that on behalf of father, husband, there was a petition or a brief that had just recently been submitted. There's been no ruling in terms of that in any way. My understanding is that there's not any sort of final hearing that I've been made aware of that is set on that, because they are still going through the base level of, do we have jurisdiction and what are we going to do with that? As far as the concern that the court has, it's a valid concern, obviously. I think there's two things I would say to that. One, we already knew that Colorado was going to do what they were going to do anyways. And this isn't giving up. Sorry. This isn't giving.
Your time is up.
Apparently. This isn't giving up. This is not the court saying that you are giving up jurisdiction under your ruling. This is us simply saying that we need to make sure that this is happening. We are trying to be judicially efficient about it, make sure that there's a uniform body of law, do all the things that are laid out for the reasons that we go under the Trap 9 appeal in the first place. I also believe that it would be appropriate to put into an order to stay that this is, again, not giving up jurisdiction under your order, and that it is not giving free rein to Colorado to move forward, as you still believe that you have jurisdiction pending any ruling by the court.
And your argument that this court lacks jurisdiction over the newborn child has been based on the fact that the Uniform Child Custody Enforcement and Jurisdiction Act says that child never resided in Dixon County, and for that reason, it is not this court's jurisdiction, even though I have asserted jurisdiction over the parties and asserted jurisdiction over their other child. And my response to that has always been that to follow that argument, that it would defeat this court's jurisdiction for any person like the mother to take a child, or if she's pregnant, to leave the state during the pendency of any custody action, and thereby defeat a father's right to have the court that's hearing his divorce action be able to, adjudicate the custody of all of the children, including the one that was born out of state because the mother left, which is exactly what we have.
And I think to respond to that, Your Honor, there's also a separate statute within the UCCJEA. I believe, if I remember right off the top of my head, that is Tennessee Code Annotated 366223, if I'm not mistaken, but please don't hold me to that. But essentially, the statute says that jurisdiction cannot be placed somewhere else if it is done with unclean hands, essentially, that it is done with the intent of trying to go through and And,
Which Mr. Thomas would argue is exactly what your client has done. So-
but it's really not, because we came here before the court. She requested to go there. She requested to do those things. Everyone knew that she was pregnant at
You
that
didn't
point.
request to take the newborn child to Colorado and give it up.
That's a separate issue altogether, because my statement is that West Virginia is the home state of the child based on the child being born in West Virginia, and anything that happens in West Virginia after that, that's in West Virginia, and that's a West Virginia problem, and that's something that needs to be sorted out between Colorado and West Virginia.
So that argument, Mr. Thomas would have to then retain counsel here in Dixon County, also retain counsel in West Virginia, and also retain counsel in Colorado, which I think is not what I believe would be the effect that the law has in mind. So I will grant your interlocutory appeal request simply for the basis that this is an unusual situation, and there is the implementation of the Uniform Child Custody and Enforcement Jurisdiction Act brings before the court issues that are not normally in one of these cases, and I'm required to make a finding as to what the issues are. So my suggestion would be that I will draft the order, but I'm going to give you both 10 days to submit to me your proposed issues that you believe require an interlocutory appeal, and then I will draft, using your both suggestions, I'll draft the order that I think is appropriate for it, but I will grant the interlocutory appeal solely as to the newborn child, and I will not grant the stay of the proceedings as to the child that was born during these proceedings, or while they were living here, because I don't think that the uniform commercial, why do I keep saying that? That was my least favorite class in law school, was the
Same.
uniform commercial code. It was the most.
We had a teacher that just read from the book the entire time.
Well, when I was in the University of Houston Law School, I know you really want to hear this, we had the guy who actually drafted it. He was like 110 years old, and he was from Harvard, a visiting professor at the University of Houston Law School. And all he did was sit and talk about going to lunch and what over lunch they talked about this provision. 50% of the class dropped it, including myself, dropped it because we were convinced that we weren't learning anything about the Uniform Commercial Code. I have never regretted dropping that class, nor do I ever want to know anything more about it. But the Uniform Child Custody Enforcement Jurisdiction Act, I think, is the key here, and that's where you need to focus what your issues are. So 10 days for each of you to submit the issues that you think need to be adjudicated by an appellate court. I will then draw the order, and if you will also submit an order granting the interlocutory appeal, then I will sign that after I've submitted, at the same time I submit my written statement of the issues.
Understood. And for the record, I previously filed already an appeal through the Court of Appeals in terms of giving notice. That one's, and I've spoken to counsel about that, it was filed under Trap 3 instead of Trap 9 because I, for lack of a better phrase, fat-fingered it when I was trying to put it through and selected the wrong thing. But we're still within there because I've got 10 days after that order is signed.
All right.
So that won't be dismissed. There will be a Trap 9 put in place.
That's
after
between
that.
you and the Court of Civil Appeals.
Exactly. I just want to put it out there on record that one's going away for that purpose.
All right. If you will send those directly to my office, please, and then that will be helpful. If you want to send them to my email address, you can do that if you'd rather do it that way, whatever you want to do. Do you have that email?
I don't know that. I don't do.
I'm going to give it to you, but I'm not going to announce it over.
You don't want to put it
airwaves.
on record for the YouTube watchers?
Yeah. You two are going to have to share. I only have one.
I'll take a picture of it, Judge.
Yeah, I
That's
was going to
fine.
say I'll take a photo of it
And
real quick.
just to be clear for the record, so the court is granting a stay with respect to any proceedings regarding baby Thomas in Colorado. We do have set today an evidentiary hearing on the father's motion to return the minor children to him.
And that brings us to the real legal cliffhanger. This isn't just about paperwork or which courtroom gets the final say. One judge is claiming jurisdiction over a child born during the divorce, while Colorado is simultaneously dealing with adoption proceedings. Now the big question is, who actually has the authority to decide this child's future? That's exactly why an interlocutory appeal matters here, because one wrong move could let two courts move in completely different directions. What do you think? Should the case stay with the original court, or should the state where the child currently is take control?